Florida has decriminalized and made it legal for information to be omitted during legal proceedings. It was the opinion of some Florida judges that omitting information is not fraud if there are opportunities for corrections to be made or if the act was admitted to the court, even if it represents bias or discrimination. This became evident after Florida attorney Renita Henry admitted to omitting her client's information in what she claimed was a temporary deviation from guidelines. On December 17, 2018, attorney Renita Henry admitted to opposing counsel Emily Phillips that she had omitted her client's information and that it was a deviation from guidelines. When attorney Renita Henry's client requested that she corrected the omissions and make them compliant with Florida Statute 61.30, she refused and withdrew from the case on January 8, 2019. This meant her client had to self-represent himself before General Magistrate Deborah Nabet Frankel in the 11th Judicial Circuit Court of Florida on January 28, 2019. Surprisingly, the General Magistrate declined to treat the omission of information as a violation while stating that the act of omitting information was temporary and that the judge would review it at the final hearing. At the final hearing on April 29, 2019, it was obvious that Judge Scott Bernstein had no intention of reporting his knowledge of omission to the authority. Instead, he advised attorney Renita Henry's former client to file an appeal. However, as per judicial canon guidelines, judges are required to report all knowledge of improprieties to the relevant authority. Judge David Miller was another bad actor who profoundly decriminalized fraud through omission on August 6, 2020, when he chose to recuse himself immediately after making a verdict. This enabled attorney Renita Henry to file sanctions against the very client whose information she had omitted. Another example of support for the decriminalization of fraud through omissions occurred when the Southern District Court of Florida Judge Cecilia Altanaga dismissed a civil rights lawsuit on April 4, 2023, against 4 11th Judicial Circuit Court of Florida judges, 2 general magistrates, and 2 attorneys. This case was dismissed 20 days before summons had been served on all the defendants. Judge Samantha Ruiz Cohen, General Magistrate Gina Mendez-Locke, Attorney Emily Phillips, and Attorney Amelia Lynn Wurchel continued to perpetuate the exclusion of information from litigants during legal proceedings as the 11th Judicial Circuit Court of Florida sustained their decriminalization efforts. Judge Samantha Ruiz Cohen and General Magistrate Gina Mendez-Locke chose to adjudicate a case without subject matter jurisdiction and threatened the defendant with jail time if there was no compliance with their fraud through omission. Furthermore, this provided an avenue for potential retaliation as Judge Cohen, General Magistrate Locke, and Attorney Phillips were defendants in a lawsuit that the litigant had previously filed against them. For that reason, General Magistrate Gina Mendez-Locke and Judge Samantha Cohen have repeatedly rejected the litigants' motions to vacate judgment. The truth is that in an uncorrupt judiciary and democratic society, omission of a litigant's information represents material misrepresentation which converts into a court's inability to adjudicate fairly. Additionally, any judge who possesses knowledge that impropriety exists in a case and adjudicates a verdict does so without subject matter jurisdiction, making those verdicts void. Whenever court proceedings are tarnished through material misrepresentation, they result in fraud on the court. Also, per Florida Statute 839.13, it is a criminal offense for officers of the court to alter any piece of information that is utilized during legal proceedings. If a court official is found to be biased or prejudiced even before fraud occurs, they are required to excuse themselves from the case, and a different official must be appointed. When judges do not follow the law, they become trespassers of the law, which removes subject matter jurisdiction or the ability to hear and adjudicate a particular case. There are some judges who label themselves as being above the law because of immunity. However, it must be noted that immunity is granted to judges to enable them with the freedom to act upon their own convictions without apprehension of personal consequences to themselves, but not to commit judicial crimes such as fraud on the court or color of law violations. Ultimately, if a judge while acting in the capacity of his authority deprives a litigant of civil rights without due process of a court, then the judge acted under color of law. Similar injustices are common throughout the state of Florida. But only limited attention has been given to the systematic practice that characterizes racketeering and corruption. What was found to be alarming is the unresponsiveness and rejection of the law by agencies such as the Department of Justice, Miami State Attorney Office, Florida Bar, Judicial Qualification Commission, and Florida Attorney General. The head of the 11th Judicial Circuit of Florida, Chief Judge Nushin G. Safai, has taken a vow of silence regarding her officers of the court's violation of due process and equality. It is the appointment of attorneys and judges to oversee their peers that have enabled corruption to change the face of justice while influencing injustice throughout the United States of America. Finally, possessing the authority to enforce justice should never translate into insulation from justice.